Good morning, and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, and I'm here every Sunday from 8 to 9 a.m. on these stations to provide landowners valuable information you need regarding the Marcellus Shale development here in Pennsylvania. And so if you're looking for landowner information, then this is the radio show for you. I represent landowners and only landowners, not pipeline or gas companies in any way. And I represent landowners and have for many years now for gas lease negotiations, doing a lot of gas lease amendments and modifications, pipeline agreements. So we talk about those quite a bit. Surface use agreements. I'm going to talk about surface use agreements today. It's something that's been popping up more and more, and that's what I try to do. I try to find issues that keep popping up and things that I think people need to be thinking about, or want to make sure that you are thinking about these things or aware of these things, and maybe you already are considering a surface use agreement or have been presented one, or maybe you may get one in the future. And there's some things you need to think about. Also, something that I've talked about many times, and I'm going to talk a little more about it today, is just because the company hands you an agreement, just because they want you to sign a pipeline right-of-way agreement, or they want you to sign a surface use agreement, or some sort of release document, just because they give you that document doesn't mean that you need to sign that or you should sign that. You need to make sure that you understand what that document is, what rights you're giving away, because anytime you're signing something, you're going to be giving something. And then the question is, well, what are you getting in return? But if you're going to sign this document, obviously you need to understand what it is, what you're giving away, but you also need to understand bigger picture of why do I have to do this, and why am I going to do this, and of course, what rights am I giving away? So I'm going to talk about surface use agreements. I'm going to explain all those today, but I just want to point out, represent landowners for estate planning issues, doing a lot more with estate planning. Many of our clients getting royalties, more people transitioning into royalties. So we want to make sure that you have the right plan in place for you and your family. Also, doing a lot more, as the development occurs, we're seeing transitions of other issues that are coming up. One of the things we're looking at a lot is, is there an issue with the unitization of your property? And we find sometimes that there are. So we want to make sure that you don't have any unitization issues or breaches of contract. Now, I want to say that many times, we get calls, people think they have a unitization issue. We go over it and say, you know what, unfortunately, I believe that what the company has done is appropriate or legal. Maybe we don't like it, but legally speaking, that it's something that they could do and not violate the law or your contract or your lease. But there have been times where we found that there have been some mistakes, or maybe that something wasn't done quite the way it was done. So we're doing a lot of work with that. I say pipelines. We have so many active pipelines with not just the gathering lines from the wells and transporting the gas to the well site, or from the well sites to the interstate pipeline, and doing a lot more with the interstate pipelines with the FERC lines. I have several clients who are in this FERC situation, and that's a different situation. So you got to understand that too. There's a whole different set of rules, and what we can do in those cases is different than what we can do in these other gathering line cases. And then within the gathering line cases, there's a lot of difference there, where sometimes we have a lot of leverage, sometimes we don't. Quite frankly, some companies pay more than others. And some companies, we know that if you ask and you press in the right circumstance, you can get a lot more money. But not only can you get a lot more money, you can get better terms to your contract. And again, I'm going to make this a pipeline show today. But of course, this is a good spot for a reminder. Check out the websites at pagasleaseattorney.com. That's pagasleaseattorney.com. Also, check out pipelineattorney.com. If you are considering or been presented with a pipeline agreement, you need to go to pipelineattorney.com. You don't need to, I'm not saying that so you go there and then you got to hire me. If you want to, great. That's what we do. But if you don't, that's fine too. As long as you have somebody assisting you with the experience and knowledge to help you out. Because there's a lot that can be done with these agreements. So you need to make sure that you're maximizing these agreements. So you can go to pipelineattorney.com, read about the common mistakes people make, look at some of the issues that you should be thinking about, and decide how you want to move forward from there. So you got to get information. You must get information. So, okay. That's pipelineattorney.com, pagasleaseattorney.com. We also have radio shows archived. Of course, I have to say it every week. I've been doing the show since August of 2010. August of 2010. So you can go check out the prior shows, 150 plus, way more shows available on the websites. So you can listen to some pipeline shows. You can listen to royalty shows. Obviously, we're doing a lot of work with the royalties and challenging deductions and things of that nature. So check out the websites and go learn more about that. The biggest thing, as I say all the time, information is the key for landowners. You need to get information. But then the second part of that information, it needs to be quality information. There is so much misinformation out there. There's so much misinformation out there. So you need to understand when you're acquiring information, who is giving you this information and what is their perspective? What is their agenda? Are they giving you this information because you're employing them as an attorney or some other way, in some other manner? But typically, an attorney, are they giving you this information because that's their job to give you good quality information? Is it somebody sitting on the computer on these message boards, in their basement or in their home office, just plugging away there? And if they are, what do we know about this person? Or is it somebody working for the company? Is it the landman at your door who's giving you this information? You have to understand who's giving you this information and then judge, how reliable is this going to be? What is the perspective where this information is coming from? Is it coming from the company perspective? Is it coming from a landowner perspective? And those are all things you need to look at, because good quality information is going to be what allows you, or it's going to be the information, it's going to allow you to make the best decision and an informed decision for yourself. So it's critical. And I say this, we talk a lot about money. I talk a lot about money in the show. I talk about, hey, there's additional compensation available. It kills me to see people sign agreements when, if they had done some more research or had somebody assisting them that knew what they were doing, they could have obtained, tens of thousands, sometimes hundreds of thousands, and honestly, on some occasions, millions of dollars more, had they been informed or not been afraid to reach out and get somebody to assist them who had the experience and understanding of what to do to maximize and to get the best situation possible for this landowner. So that's occurring, and I just hate to see it, because what will happen sometimes is the landowner will come to my office with a new agreement and retain me to represent them in something else. So when we look back and they provide me some of the background information, I see an older agreement. I look at it, and sometimes I hate to even ask, because I can tell what would have occurred back at this time. And I say, did anybody help you with this? Or, what was the history? And usually it is, well, we didn't get anyone. We didn't think we needed anyone. The landman said this, the landman said that. So we just went ahead and signed it. We thought we were going to getting royalties, and, we thought it was the right thing to do. And the point there, many times it's just simply not the right thing to do. And I stand by, whether me or anybody else, you need to make sure that you have experienced assistance and legal counsel when you're doing these documents. You just need to do it, because these are documents that are going to run for decades and centuries into the future. And there are so many tricks involved in this process that you need to understand them. And just doing this for the first time, or only seeing a couple of these agreements, or relying on your neighbor, I'm telling you, I come across new tricks every week. So it's really difficult, and I'm working, I'm literally 6-7 days a week. I'm at the office working, reading contracts, working on files for the clients. And what do we see? We see new things all the time. So I want you to be informed. I want landowners to be informed, but please understand that there's always more to learn. And as much as you are informed, as much information that you have, there's more information out there. So we want to make sure that you're getting as much information as possible, the best, highest quality of information possible, and then making the right decision for you in what you're presented with. I am Attorney Doug Clark. This is All Things Marcellus. I'm here every Sunday from 8 to 9 a.m. on these stations. So jumping back then. So we want to make sure that you as the landowner are getting this good information and that you're making the right decision for your circumstance. So what I'm going to talk about today, I'm going to talk about surface use agreements. Surface use agreements, sometimes called SUA for surface use agreement. We're going to talk about those. Now, just because I use this word surface use agreement, if you get a document for the construction of a well pad on your property, a proposed construction, and there's some sort of contract that you're getting, well, that may be called a surface use agreement, or it might be called a well site agreement. Pick a name. Different companies use different names. So just because I'm saying surface use agreement, don't think, I have a different company and they sent me a well pad agreement, or they sent me an agreement for a meter station, a valve site, even a compressor station. You can't just say, okay, well, it doesn't say surface use agreement. That's not what this guy's talking about. No, I'm talking about a document that's often, or an agreement that's often called actually surface use agreement. But it could be the same thing for a meter site, a well site agreement from another company, a compressor station, pig launcher, and so on and so on and so on. Same type of thing with like rental agreements or storage agreements. Even roadway agreements can be, it's an agreement to use the surface of your property. So we want to make sure that when you get this agreement, that you understand what you're presented with. One of the things that I've said many times in the show, and going to talk about this today quite a bit, is just because you have an agreement presented to you, a lease agreement, a contract for a well site, a roadway, a pipeline, etc., here. Just because you're presented with this agreement doesn't mean that you need to sign this agreement. There are times, and we're going to see transitioning as some of these better leases start to get developed, like as you see these Wyoming County landowner group leases and these leases that were done as groups, as they start to be developed, meaning as well pads start to be constructed on the property, as pipelines, as roadways, as that starts to happen, and it's more and more occurring now because these leases are starting to run towards the end of the time of their initial term. So once we see that this is starting to develop more, well, now we have a baseline lease that we need to look at to say, what can the company do under the terms of my lease agreement? What rights do they have? And if they come to me and present me with a surface use agreement, a well pad agreement, a roadway agreement, a pipeline agreement, and so on, if they come to me with these agreements, number one, do I need to sign this? And then, well, maybe, first off, you never need to sign these type of agreements, in my opinion, in almost all cases. But not only do you maybe not need to sign it, but should you even be considering signing this, because the terms of this new agreement are less than, they're not as good as, they will change your original lease to the negative to you. They're less than what the terms are and the protections that you have in your actual gas lease, which is the foundation of these operations. That's the framework as to what the company can do in the future. So if your lease has very strong protective provisions and maybe even good compensation provisions as to how you're paid, for example, if a well site is on your property, well, do you need to sign a surface use agreement? And if you do, why are you going to do it, and how is it going to change the terms of your lease? What are you going to be giving up? So I'm going to talk quite a bit about this today. I'm up against this first break. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, here every Sunday from 8 to 9 a.m., and I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. As always, I'm here every Sunday on these stations from 8 to 9 a.m. to give landowners valuable information that you need regarding the natural gas development here in Pennsylvania. Again, you can always contact me directly at 570-307-0702. That's 570-307-0702. I mentioned the websites in the first segment. Very important. Go check out the websites for information. Whether you're looking for representation or just information, check out pagasleaseattorney.com, pipelineattorney.com, one of the two or both. Think there's value obviously there for both. pagasleaseattorney.com and pipelineattorney.com. I'm very excited. It's going to take a little bit of time, but we're revamping, doing a lot of work here behind the scenes on the websites. I'm writing more content and more text to put up on the sites. We're going to be just redesigning the whole thing, so I'm really excited about it. It's a big project, something we're working on, and I have a new designer, so I'm really excited about this. So, check it out now. I'll be talking about the revamping and reworking in the websites as we go forward, but check them out now. Get a feel for them, and then again we're getting pretty excited when we release them and launch the new sites. You want to definitely make sure that you check those out, because we're going to add some more content segments. We're going to reorganize it. We're going to make it even more landowner friendly. We have the radio shows up there, and we're going to continue to post them. You can also, we're putting the radio shows up on YouTube now as well. And when we first started out, we would hold the shows back a few weeks before we'd release them. But quite frankly, I want to get this information out to people. So if you're interested, you have immediate access. So you can go to YouTube, type in All Things Marcellus, check out the broadcast there. We also put the show up on iTunes. You can go to the podcast section there and type in All Things Marcellus. And of course, everything is free everywhere. We want to make sure that you're thinking about these things. I'm giving you things to think about. Maybe you weren't thinking about. And look, don't want this to be a big giant commercial, but the truth of the matter is that landowners really do need to get legal assistance with these agreements. And I've said this, and I'll keep saying it. It's not saying call me. It's saying you need to get legal assistance, whether you call me or somebody else. And the other thing I really would want to focus landowners on is you want somebody, as always, that you're comfortable with, that you believe in, that you have faith is working for you, and you're comfortable communicating with this person, and that they have the experience to assist and help you. Because so many times as we deal with these evaluations and we're looking and we're positioning in these negotiations and these contracts, experience is so helpful. And if you don't have that experience and you can't say, well, faced with this situation on other occasions, here's how this company reacted, well, that's information will be helpful for you. And that can really turn around and end up meaning that ultimately you enter into an agreement for less compensation or less protective terms. I said before, I talk a lot about compensation because we don't want to see landowners sign agreements when, if they knew what they were doing, or if they knew to ask, or if their attorney knew to ask, then maybe they would have got hundreds, thousands, or even hundreds of thousands more dollars. So that's what I'm saying. We want to maximize compensation. To me, it's that simple. But there's two parts to this, and I have clients say to me all the time, "Hey, look, it's not about the money. It's not about the money." Well, okay, I understand that. But if a company offers you $50,000 for something and you could get $75,000 with very little effort, would you want to do that? Well, yeah. Hey, it's not about the money, but I'm not going to say I don't want extra money for the same exact agreement. It's just simple. It seems to me pretty simple. But at the same time, if you're able to get more money, well, it stands to reason you're going to also be able to better this contract in many other ways. This pipeline agreement, this surface use agreement, meter site agreement, you name it, roadway agreement. You have to explore these issues. You have to be looking at this. And remember, you're entering into a contract with a major company, an oil and gas company, who in many cases have operations across the world, or at least the country. So, this is serious business, and you need to handle it that way for you. You didn't, look, you didn't ask to be in this situation, but you are in this situation. So you want to make sure that you're protecting yourself and also your family, future generations, that you're doing this the right way. Many times, just asking certain questions or knowing to put certain things into your agreement can result in a lot more compensation, sometimes double the compensation, can result in having a lot less problems in the future. How are they going to reclaim the area? When are they going to do it? The seed mixture, all of these type of things, want to make sure that you're getting the best possible agreement. I am Attorney Doug Clark. This is All Things Marcellus, here every Sunday from 8 to 9 a.m. So I talked earlier, and here we're going to jump in this now. Okay, so what happens is you enter into an oil and gas lease, and maybe you did it 5, 4, 3, 2, we might as well go 1 year ago. So you enter into an oil and gas lease at some point, and now you next knock on the door comes, and the company wants you to sign, or they're offering you, usually and most common, is a pipeline agreement. Again, first thing you do, listen, say nothing, contact somebody and start figuring out what you can do and what you need to do. All right, stepping back from there. Landman comes out, says, hey, we want to do something on your property. We're going to talk today about, we'd like to put a well pad on your property. For some people, that's a very exciting and a very good day. For other people, it's a major disappointment and a tragic day for them because they don't want to have the well site on their property. They love their property. They've been living there for years, or even if they just bought the property, maybe they wanted to build a house someday. Maybe they wanted to retire there. Well, a well pad, roadway, and related facilities on their property isn't something that they want to have. They don't want to have that on their property. Honestly, my position is if I had a choice and I was a landowner who was in an area of development, I definitely, to me, would never want to have a well pad on my property. I wouldn't want it. However, with the good, with the compensation, with the bonus money for the lease, with the potential of future royalties, there's a quid pro quo. There's something exchanged here. Well, in that exchange, typically one of the major rights that you're giving up as a landowner is to allow the company to operate on your property, including constructing a well site, an access road, and related facilities on the property that are necessary for the company to extract the gas. If I had my choice, it's the classic thing. I'd rather see it on my neighbor's property or a couple neighbors over. Your key as a landowner, to me, is you want to have all your property in a unit. And to me, the ideal situation would be all of your property in a unit. And so you're going to get royalties for all of your property, but no activity on your property. That's great, because in those circumstances, you truly have a situation where you're not seeing any activity on your property. Now, you may see it on other areas, but you're not seeing it on your property, and you're fortunate enough to get royalties, so you're walking out to the mailbox and getting that check. The landowner who has the well site on the property, they're doing the same thing. They're not getting any extra royalty money because they have the well site on the property. They're going to get a payment for damages, and depending upon what their lease says and what they negotiate, they're going to get some money to have the well site on the property, but rarely. And actually, I don't know that I've ever seen it where the money paid to the landowner, it justifies the impact on the property. In other words, a common number we'll see out there is a company will say, well, we'll pay you $15,000 to have a well site on your property. Well, let's say that well site is 10 acres. Well, over time, if you had your choice and would say, I'd rather not have a 10-acre industrial facility on my property, I'm willing to give you back your $15,000, especially if you're getting royalty money now too. So if you're fortunate enough and say you're getting $5,000, $10,000, pick a number, in royalties a month, you'd be probably pretty willing to skip a month or two of royalties in exchange of moving that well pad to somewhere else. However, in true, with the good comes the bad. With the royalties, with that bonus money, you're giving up something, and you're giving the company the right to operate on your property. That's part of the deal. And that's a deal that people make all the time. And clearly it's a reasonable deal. It's reasonable. This money doesn't come for free. Now, sometimes it may even seem like that if you're fortunate enough where you don't have activity in the property. They give you a bonus, then they start paying you royalties. But it wasn't for free because you had the risk of having activity on your property. And maybe none has occurred. Maybe it'll occur in the future. Maybe it will never occur. But in this contract, your risk is that you may see this type of activity. So it's really important if you're going into a lease is to understand that, and also to understand what type of activity is this. The days of, oh, hey, we're going to just take an acre, it's going to look like a golf course. Landowners aren't going to fall for that anymore. They've seen well sites. They've seen this, what's going on. One of the things while I'm here, it just kills me with these guys. They talk about, oh yeah, we're going to reclaim it. Again, golf course. Oh, it's going to look so great. We're going to reclaim it. Well, ride around and see how many of these well sites are drilled out completely. And here's what I mean by that. That the company may permit 6 wells, could be 4, could be 10, whatever the number is. I've seen one recently, it's a 10 well pad. They permit 10, drill 9. They don't drill the last one. Well, since they haven't drilled the last one, they don't need to reclaim that area. So the well pad is still really big. The roadway, everything is there because they are going to come back and drill another well. Or take another case where, Chesapeake, great example, drill a well, have a unit and, plan 4, 5, 6 more, but they pulled out and they've gone somewhere else. So everything is remaining the same. So this whole idea of, oh, we're going to reclaim it, it's going to look great. Well, the question is, well, when are you going to do that? When is the company going to do that? And they're never going to give you a time frame in your lease. It's just never going to happen because we're not seeing a lot of cases where that the company is gone. They've constructed a well pad. They've got the rig on there. They drilled 4, 5, 6, whatever they're going to drill. They pick up, they move out, and now that pad is reclaimed back to the smallest size possible. It does occur, but it's not something that's occurring regularly. That's for sure. And I am Attorney Doug Clark. You're listening to All Things Marcellus here every Sunday from 8 to 9 a.m. I'm going to talk now about landman comes. You enter into a lease. Landman comes. You have a surface use agreement. In this case, we'll talk about a company wants to put a well pad on your property. Again, my belief is, not too crazy about this, but this is when you say, okay, let me listen to what you have to say. Let me make no commitments whatsoever. Please do not commit to money. Do not commit to location. Do not commit to anything during any initial meeting. It makes no sense. Listen, say, well, let me think about things, but don't commit to anything. So, comes out, says, we want to put a well pad in the property. What's the first thing you do? You say, okay, I'm going to listen to you. But whenever this gentleman leaves, or if you have it handy or lady, go get your lease. Take the document they've given you, this surface use agreement, get your lease. And now we got to start studying. We got some work to do. We got to go through your lease and we got to figure out every single word in your lease that dictates or has some control over well pad construction or surface operations. We pull that out. We look at what the surface use agreement is, and we start making an evaluation. Is this something that you want to pursue? Or maybe you say, you know what, I don't want to reach an agreement. I'll just go under my lease because I have more protections under my lease than what's offered. Or maybe you say, yeah, I'll sign a new agreement with you, company, but I want to make sure that all of the terms in my lease that deal with protection of my property during development, that they're all part of this new surface use agreement. Very important. We get back, I'm going to talk about a surface use agreement and talk about a case where, in this case, the landowner very clearly is better off by going under the terms of their lease and not the surface use agreement. So you got to have this evaluation. I am Attorney Doug Clark. You're listening to All Things Marcellus. I am here every Sunday from 8 to 9, and I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, here every Sunday from 8 to 9 a.m., talking about surface use agreements now. And also, Now remember, just because I'm talking about surface use agreements doesn't mean the same evaluation process doesn't apply to other agreements like pipeline agreements, well pad agreements, meter site agreements. All other type of agreements still fall into this type of analysis, but we're going to really get into the surface use agreement today. And again, surface use agreement is a name that some companies use, but not all companies use for documents that are going to involve surface activity on your property. Resetting briefly, you have signed a lease. Now the landman company comes, knocks on your door and says, we want to put a well pad on your property. You're going to listen. You're not going to commit to anything. You're going to listen, find out what's going on, and just take the information they have, and you're going to pull out your lease. And what you're going to do is when you're going to look at your lease. Now, obviously, if you entered into a lease early on in the process that doesn't have additional addendum terms, it's a form lease, well, we're not going to have near as many protections for your property as you're going to have if you entered into a negotiated lease with more addendum terms. Now, more doesn't always mean better, but what we're seeing is now, the earlier people who signed poor agreements as far as didn't have many addendum terms. So the companies really had a lot of flexibility on how to operate on the property. But now we're getting in, as we're in 2014, we're getting into development of leases that have much stronger terms for the landowners. So those agreements that the company would use, the surface use agreements, these newer agreements that companies would use with landowners who signed bad leases, well, you know what? They're not going to work in these cases now, and a lot of times. You're going to have to do something different, company, because these landowners who are transitioning, who are circling in now with these newer leases, these landowners have strong leases that you have to comply with. So landowner, please, when you hear something like, well, this is what we do all the time, when you hear that, please step back, because just because they do something all the time doesn't make that relevant to you in your situation. Because they give people bad agreements doesn't mean that you have to agree to a bad agreement. Or maybe all of these surface use agreements that they've been using with landowners, they've been having landowners sign because those landowners had really bad leases and didn't really have any good alternatives. But you, if you pull out your lease, you get somebody to help you, you look at this, you find out, what can I do? Well, you may have a much better circumstance. In this case, and I can't get into the numbers on this one case that I've been working on for a while and worked quite a bit on over this last week. By going under the lease, this landowner actually got much higher compensation by going under the lease. Now, this isn't always the case, but going under lease, much higher compensation that was being offered under a surface use agreement, and way more terms and protections. And then the kicker of all was we were able to keep legal fee costs quite low in this situation because we didn't have to negotiate and fight and work to get terms from the lease incorporated into the actual surface use agreement. We were able to reach an agreement to use the lease, and then also reach an agreement as to how the compensation is going to be paid, and avoid this long negotiation process and do this in a much cleaner fashion, which is going to result in more compensation to the landowner and also going to result in a much lower legal bill because we don't have to do this other process and also go through this other process, and also going to give this landowner all of these protections that they had previously negotiated for, where if they would have signed a new agreement, less money, less protections, and probably more costs associated with trying to fight and claw and scratch to get terms that you should have because they were in your lease. Now, we have this all, I should say, it's all been agreed to, but we're still working on the final steps of finalizing this particular case. Okay, I am Attorney Doug Clark. You're listening to All Things Marcellus here every Sunday, 8 to 9 a.m., talking about surface use agreements. I'm going to get into now some specific language of a surface use agreement provided to a client of mine. Now, this one was in Wyoming County. Same type of thing we see in Susquehanna and Bradford, very common. So in this particular case, this surface use agreement goes on to say that it's for the purpose of building an access road and or drilling pad known as the certain pad for just a name, and I don't want to give the name out here, but for drilling, completion, production, operation, maintenance, reclamation, plugging, and or abandonment of oil and gas wells thereon, and the surface owner, meaning you who would sign this, is agreeable to same. So very broad purpose, not a lot of details here, and saying that you're agreeable to same. So again, we got to understand what that means exactly. We need to understand what your lease says. So that's the kind of introduction part of this agreement. Goes on to talk about, it states it states some compensation where they'll say like for $1 or $10 because you're required to do that in these agreements. Saying though, it goes on to say that the landowner does hereby release and discharge the operator from any further payments for timber, crops, earthen materials, get this one, or any other item, however, arising as well as any and all surface damages to the lands resulting from the operations of the operator under this agreement. On the damages, on the lands, including without limitation, damages to land, buildings, fences, crops, timber, earthen materials, or any other item. That any other item appears twice in that same sentence. So, look, this is giving you, at least they're being upfront, just saying we're going to give you money, and that's covering everything. That's covering damages. If we damage a building, if we damage fences, crops, timbers, your land, earthen materials, or any other item, that's the money you're getting, and that's the deal you're striking. So you better be very happy with this compensation. But what concerns me, and I've talked about this one before, but to me this needs to always be changed, because if you're agreeing to a well pad to be built on your property, there's permitting documents that go through DEP, and there's a defined what they call limits of disturbance. You'll hear it called LOD, limit of disturbance, meaning what is the outside area where the company can disturb, how many acres, 10, 15, whatever that number is, to build this well pad. What is that outside area, or the limit of disturbance, the amount of disturbance that they can cause. So when you enter into an agreement for development of the property or for damages, shouldn't those damages and that payment be limited to only the area that they're supposed to be operating in? So if you have a limit of disturbance of 12 acres and the company accidentally, intentionally, whatever occurs, goes outside of that 12-acre area that you're aware of, then you have damages that you didn't foresee when you were entering into this agreement with the company. So you should not be releasing the company for damages beyond what you're contemplating. So if the company says we're gonna have an impact on 10 acres, and you say, okay, I'm willing to accept this certain amount of money in exchange, I understand you're going to damage my 10 acres. Well, they come out and they damage 15 acres. Well, shouldn't you have more money for that? Because that wasn't what you had negotiated. That wasn't what your agreement is. But when you start signing agreements that says, we're going to give you this amount of money, here's where we plan on operating, but this release, or by signing this agreement, you're agreeing to this money, and that's covering everything. Any damages anywhere. It doesn't say limited to this area of operation. So we want to limit these damages to the area where where you agree and know they're going to operate. And these aren't secrets because they permit this area. They have to submit the documentation to DEP to say where they're going to operate. So you need to have that information, and you don't want to release more than what you have to and go beyond what your agreement is. I am Attorney Doug Clark. This is All Things Marcellus, here every Sunday from 8 to 9 and talking about surface use agreements. So going on here. So I'm kind of going through a real surface use agreement for a proposed well pad in this case. Okay, so want to go on. It states that for this consideration, the surface owner also grants, conveys, and assigns to the operator an exclusive and unrestricted right-of-way and easement over, under, on, and through the owner's lands or owner's property for the construction, installation, operation, repair, replacement, maintenance, reclamation, and or removal of an access road and drilling pad, as well as pipelines, tanks, fences, pits, here we go, and any other facilities or equipment necessary or convenient for the drilling, completion, production, operation, maintenance, plugging, and or abandonment of any well or wells drilled on the lands or on other lands. Or on other lands. Okay, goes on. This is still the same sentence. And does hereby grant, bargain, and convey unto the operator a subsurface easement. You're also conveying a subsurface easement. I'm going to talk about that because I'm sure most people have no idea what that is, and just because it's very rare. So you're also conveying to the operator a subsurface easement and right-of-way to use and occupy the subsurface of the lands for a well bore or well bores, including, without limitation, the right to drill across, through, and under the subsurface of the lands, together with the right to use earthen materials as needed. Wow. I'm sorry. I hope you're able to stick with me. That's one long sentence. That is one long sentence. Now, I've read this sentence many, many times, and it's a tough sentence. And you have to understand, you read these words, everyone can read the words, but understand what do they actually mean, and what's this going to mean in the future. So you have to understand, and I'm not saying that ultimately these types of agreements don't get signed. I have clients who we sign these agreements regularly, but there's things that we do with them for sure. But you're giving the right. You have to understand. Right of access road, drilling pad, pipelines, tanks, fences, pits, and other facilities or equipment convenient to the company for drilling, completion, production, and operation for the wells drilled on the lands, which means your property, or on other lands. I despise that language. I cannot stand that language. What does that mean? Have you given them right to build an access road, tanks, fences, pads, all these other pits as convenient for operations on your property and other people's property? Is that what you're doing here? You need to know this. Then it goes on to say you're giving them a subsurface easement to drill under your property, meaning to drill from the pad under your property to go under your property to other people's property, and they can keep that well there as long as they want to have it, even if you're not getting any royalties from that well. So your pad, when you give a subsurface easement, can be used to drill wells to other parcels or other units that your property may not even be involved in. Or, in cases, if they need to subsurface, it's because you're not involved in it. If it's going to be a well off of your pad that's going to be into a unit that includes your property, well, it's going to be allowed, so you don't need a subsurface easement. They request subsurface easements to drill wells that they otherwise don't have the right to drill. You need to understand a subsurface easement. I could probably do a half a show on that, so I'm not going to do that right now. I'm up against yet another break here. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, here every Sunday from 8 to 9. You can always contact me directly at 570-307-0702. Got to check out the websites, pagasleaseattorney.com, pipelineattorney.com. When we get back, I'm going to finish up with this SUA, and I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am here every Sunday from 8 to 9 a.m. You can also check out the shows on the websites at pagasleaseattorney.com, pipelineattorney.com. And again, if you need direct assistance, you can contact me anytime at 570-307-0702. Talking about that surface use agreement. So I want to jump right back into that because I got a short final segment here and say, okay, so went through in those other segments, okay, what rights are you giving up? Well, you're giving up a lot. Now we're going to say, okay, let's compare that. What were you giving up in your lease agreement? Just summarizing, the rest of the document goes on, the rest of the surface use agreement goes on to say a couple important things. One is that when you do this as the surface owner, you're responsible to a tenant if there is any. So if you have a farmer or if you are renting your property or leasing it to a farmer who's using the property, farming the property, well, if they have a claim saying, hey, because of this operations, I haven't been able to farm the property, well, you're responsible to them. When you sign this agreement, you're saying, I'm taking this money and I'm going to be responsible. So you got to be careful. You may have a contract out there, 5-10-year lease for a farmer to develop your property, and maybe the company is offering you only a little bit of money, and your liability to the farmer is going to be higher because you have an agreement with them where they're going to farm your property, and that's going to generate income, and now you're going to be breaching that agreement because they can't farm that area of your property. So something to think about. All right, so also talks about that in the future you have to agree to sign other documents as needed. This one, you'll throw in terms that have special provisions. And this one has a special provision saying that the company would indemnify the landowner. Very important provision. If there's an accident, an injury, if there's a problem, environmental, whatever the issue is, we want to make sure that you as the landowner are not going to have any liability. You also want to try to make sure that you don't have any expenses dealing with it. You don't even want to have to hire an attorney. You want to have the company defend you. So that's very important language. Anytime you're signing an agreement, you need to make sure that you have indemnification language if at all possible. And usually it is possible. Very important language. But all indemnification provisions aren't written the same. They're not all written the same. So it's very important that you have a strong provision, not just any old provision, especially in a case like this where the indemnification language in the lease was great, strong, fantastic language to protect the landowner. The indemnification language offered in this surface use agreement, nowhere near as good. So if you sign this surface use agreement, you're not getting the same liability protection. You're not getting the same protection that you had under your lease. So that's one just glaring example that you don't want to be offering yourself less protection by entering into another agreement unless you feel that the benefits outweigh that risk and that reduction of liability protection. That's just one example. Just one example. Now, I said before, kind of the theme here, I wanted to go through a surface use agreement and also, though, talk about, well, look, it sometimes may not be in your best interest to sign the next document, whether a pipeline, roadway, surface use, well pad, whatever that agreement is. It's not always in your best interest to sign it. So stepping back, remember we said, okay, you enter into a lease. Landman comes out. We want to put a well pad on your property. Your lease allows a well pad on your property. However, we need to pull that lease out and see what restrictions. Yeah, maybe allows a well pad, but what restrictions are there? We got to look at that. So I just went through the meat of a surface use agreement. Now let's turn around and let's look at this lease and some of the provisions in the lease that you'll see weren't covered in the surface use agreement. And very important provisions. I'm just going to highlight some because I don't have a lot of time here left today, but this is going to give you a good idea. Also, like I taught before, this is a situation where this person has a very strong lease. Many leases that are starting to be developed now are much stronger for the landowner, better terms. So the agreements companies were giving people when they were dealing with people that had very poor leases, well, now those agreements should be changing because now they're dealing with landowners in a lot of cases that have much stronger leases. So we don't want to sign the same type of an agreement that somebody else signed because they didn't have any leverage or protections. We need to make sure that we're maximizing your circumstance. So, couple things. One, you didn't hear me say anything about clean and green. Well, the lease provided payment for any and all clean and green, rollback or penalties. Well, that wasn't provided for in the surface use agreement. Well, that's a huge problem because you're going to get penalties and back payments if you're in clean and green. And in some counties, they're charging a commercial rate of $1,000 to $1,500 per acre. Per acre that's going to be left out of clean and green. Well, it's simple. Look, figure it out. You're talking about quite a bit of money, $10,000 or more, that you may have to pay right off the bat. Where if you incorporated your lease provision or you had clean and green language, at least the penalties and rollbacks would be covered by the company. I mean, how glaring is that issue? How glaring is that? You need to make sure something like that is handled. That's so easy to point to. Also, say you have a 5-acre pad now and say it is reclaimed. It's 5 acres. Well, if they're taxing it at $1,000 per acre per year, that's $5,000 every year as long as that well pad is there. And that pad may be there for 50 plus years. That's a lot of money. You need to be thinking about these things. Is there something you can do about that? Also, I talked before, the lease itself in this case had great indemnification language. The indemnification language offered in the surface use agreement was nowhere near as good as what the lease language was. Also, the lease language, it's important. It was negotiated for. It provided for insurance requirements, the company to provide insurance documents to the landowner to make sure there was coverage. This lease also provided a bonding requirement where the company would have to put up a bond to make sure that they conducted, in the event that they didn't conduct their operations in the proper fashion, then this bond would be available that the landowner could go after and seek to access. There were gates for roadways, fences. You don't see anything like that. This particular agreement had some great roadway language. We have language that talks about how wide the roadway can be, the type of materials that can be used for the roadway. Remember that surface use agreement just said, hey, we have the right to put a roadway there. No details about the size, width, how it's going to be constructed. The agreement in the lease had a lot of information and a lot of ability for the landowner to have input as to where items were going to be located. No discussion about that in the surface use agreement. However, in doing a surface use agreement, to me, step one is you need to have a map. And it needs to say this is where we're going to operate and this is the only place where I'm agreeing to. And if we're going to operate somewhere different or you are a company, then I have to sign a new agreement. Okay, there's pages. There's literally multiple pages stating how the company has to operate under terms of the actual lease. Timber. Do you get to keep the timber? Where's the timber going to be? Do you get it appraised? How about stump removal? All of these things that are in the surface use agreement, very vague. This lease, very detailed, talking about what has to occur. Stump removal, marketable timber, non-marketable timber. I talked about the roadways, having a 30-foot travel corridor in the lease itself here. So it could be no wider than 30 feet. You have to watch. Also, they can't clear wider than 40 feet. I've seen roadways where they're clearing literally 100 plus feet. You got to be careful. You have to understand. You have to know what's in your lease. Pipelines here. All kinds of language about pipelines. Remember when I read the surface use agreement? It talked about having the right to run pipelines. Didn't get into size of the lines or the width of the easement. It just talked about, hey, we have the right to run pipelines. A lot of information in this agreement, in the lease agreement, talking about what type of pipelines, how the lines have to be buried, how wide the easement can be. All of these things need to be incorporated or covered when you're doing these other agreements. So in this particular case, so I'm going to finish this up here. In this case, this landowner was better off using their lease than a surface use agreement. They're actually going to be better off using their lease than a future pipeline agreement in their circumstances. And without getting into confidential information regarding compensation, the compensation I can say is going to be better under the lease than the surface use agreement. So why would you ever sign it? Well, they're not going to. And that's what you need to understand as a landowner. Is that in your best interest? Okay, I'm up against it. Sorry about this. I am Attorney Doug Clark. You're listening to All Things Marcellus. I'm here 8 to 9 every Sunday. Be here next week. Have a great week, everyone.